welcome to Verdictum. I am Ananya Singh and today we are going to take a look back in time on some of the most notable judgments pronounced by Justice Dinesh Maheshwari. But before that, let's take a brief look on the life of Justice Maheshwari. Born on May 15, 1958 in Udaipur, Rajasthan, Justice Maheshwari did his LLB from Jodhpur University in 1980 and enrolled as an advocate with the Bar Council of Rajasthan on March 8, 1981. He practiced law for 23 years before he was elevated as a judge of the Rajasthan High Court in 2004. In 2014, Justice Maheshwari was transferred to the Allahabad High Court. In 2016, he was sworn in as the Chief Justice of the Meghalaya High Court. And in 2018, he went on to become the Chief Justice of the High Court of Karnataka. In the year 2019, he assumed office as the Judge of the Supreme Court. And after serving 4 years at the top court, he retired on May 14, 2023. During his tenure as a Supreme Court judge, Justice Maheshwari was part of 444 benches and authored about 111 judgments. Today we will discuss some of the notable judgments by him. Number 1. Janhit Abhiyan versus Union of India. This case dealt with the 103rd Constitutional Amendment, providing reservation to the economically weaker section. The court, with a 3-2 majority, upheld the validity of the said amendment, and Justice Maheshwari wrote a majority opinion. It was held that the reservation extended to EWS was valid, and that it was reasonable to exclude SC, ST and OBC persons from the ambit of EWS reservations. Number 2. Odisha Vikash Parishad versus Union of India. A 3-judge bench of the Apex Court comprising the then Chief Justice of India S.A. Bobde and Justices Dinesh Maheshwari and A.S. Bopanna modified an order passed on 18 June 2020, which provided that there shall be no Rath Yatra in the city of Puri or in any other part of the state in the year 2020, as it could lead to the spread of COVID-19. The issue before the top court was whether it can intervene in the religious proceedings of a state when the public health and safety is in question. The Supreme Court allowed the Rath Yatra while issuing directions like allowing minimum number of people to participate in the Yatra. The top court noted that the state of Odisha has a good record of having controlled the pandemic with a very little loss of life. We see no reason why the same attitude of care and caution should not be applied to the Rath Yatra. Number 3. State of Madhya Pradesh and others versus Bherulal. A bench of Justices S.K. Kaul and Dinesh Maheshwari remarked that the Supreme Court cannot be a place for governments to walk in when they choose, ignoring the period of limitation prescribed. The court was hearing a special leave petition by the state government of Madhya Pradesh, which suffered a delay of 663 days. The court observed that where there are such inordinate delays, the government or state authorities must pay for wastage of judicial time, which has its own value. The government was then directed to deposit a cost of Rs 25,000. The Apex Court sent a strong signal to the government with its stand on the issue and further said that if the government machinery is so inefficient and incapable of filing appeals or petitions in time, the solution may lie in requesting the legislature to expend the time period for filing limitation for government authorities because of their gross incompetence. This is how the judiciary changes course and attitudes of not only the general public but the government, giving a hand in making the system better and robust to work for the general public. The courts also pave way for free exercise of religious beliefs, while also ensuring the safety of life and limb of people. And Justice Maheshwari has played a major part in all these developments for as long as he served in the Indian judiciary. With that, I am Ananya Singh. Thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal news.